All right. Welcome back, everyone who just attended tech training. Now we're at contracts training. I'm going to give everybody just a few minutes to be able to hop in. Today we're going to go over mutual release of purchase agreements. So what this is in a situation where you have a completed purchase agreement, a contract on a home. So you have a buyer or maybe you have a listing and somebody wrote an offer on the home and it's been accepted by all parties. And for whatever reason, it falls apart. It could be inspections, it could be appraisal, it could be buyer changed their minds, seller changed their minds, anything along those lines. And both parties, basically agree that, hey, this deal's done. There's nothing we can do to save it. Then you need to actually fill out a mutual release form. So depending on which office you're in and which board you're part of, depends on which form you're going to use. I'm going to start with the HCAR form because it kind of is one form, and then Elite, we have two separate forms depending on the situation. But I'll walk you through all forms, and then at the end, I want to walk through the situations of earnest money released should all the parties not agree on where the earnest money should go. Okay, so to kick off, we're going to open up again our HCAR form. And this is the sales and purchase release contract. It does say at the top that it's a legally binding contract, and if somebody doesn't understand it, we do encourage them to seek legal advice. To fill this out, you're going to fill out the first section is the date in which this is being released. So if I'm filling this out for today, I'm putting in today's date. And then the next is the seller's name goes in the next box. You can see blank as seller. So that tells you this is a seller box, and blank as buyer. So this goes in here as the buyer's box. Here do release each other from the accepted sales contract dated blank. So this is the date that is actually on your purchase agreement. You'll input that part here. In connection with the sale of the property located at, and on this long line, you're going to put the actual property's address. Then at that point, then the sellers and buyers will go ahead and sign section A. Now, don't send it yet, though. I want to be clear. Don't send it because that's just letting you know they're signing the agreeing to release. But we still got to fill out section B, which tells us where the earnest money is going to go. So to fill this bottom section out, it very simply goes the buyer or seller. You can circle one or use a strike through. So if you're representing the buyer, you could strike through the seller or circle it. Hereby request the earnest money, which is deposited in the escrow account of who's holding the escrow. If we're holding it, it's Keller Williams Elite. If another brokerage is holding it, it's whatever that brokerage is, or title company, if a title company is holding it, in the amount of, what's the escrow dollar amount, to be released, and authorizes who the broker is. So for us, if we're holding the escrow, it's going to be Kellyanne Harris. If it's XYZ Realty is holding it, then it's going to be whoever their broker is. To pay the deposit directly to, and then you're going to put in either the buyer's or the seller's name, depending on what you negotiate, what the obviously your contracts say where the money is going to go, but we got to get the parties to agree. So just because a contract says that if somebody can't qualify for financing, then they get out of the contract, or they get to cancel the contract and earnest money is returned to them, we still got to get the sellers to sign off to agree to it to immediately release the earnest money. So in here, in this situation, you would write down the buyer's name. And then it says, if either party disagrees with the release of the good faith broker, you must follow the guidelines of KRS 324-111. I'll explain what that is at the end. And then it says, this is important, this is on both Heartlands and Elites, seller and buyer hereby release all parties of any and all liability associated with the condition of the property, information gathered, communicated with such property. All parties acknowledge the conditions and contingencies of the sale and purchase contract have been satisfied and shall have no expressed agency, warranty, current or future liability of any of the above parties. What this basically means is once everybody signed this, if everybody agrees and everybody signs it, they can't come back and basically, start litigation later on, because once they've signed this, they're saying we accept the release, we accept where the earnest money is going, and we agree to not pursue this any further. Is the way that I want you to think about this. That's why this form is so important to get filled out. Then all the buyers sign, all the seller signs, and then the brokers sign as well. Now we have this same form for Elite, but it's in two separate forms. So we have the mutual release of purchase agreement filled out the same way: date, seller's name, buyer's name, property address, to the holder of the earnest money, who's holding the earnest money, in the amount of, how much is the earnest money, to who. So this is going to, in a made up scenario, the buyers. after all parties have signed this agrees. And then it has that same statement, but different verbiage, but same meaning, that says that the sellers and purchasers will release Keller Williams Elite and any agent thereof and XYZ Realty, whoever the co-op agent is, for any past or future obligations concerning the stated purchase agreement. And then everybody signs and initials at the bottom. So this form for Elite is if everybody agrees where the earnest money is going to go. But every once in a while, we'll have a situation where people don't agree on where the earnest money is going to go. The seller thinks they have the right to it. The buyer thinks they have the right to it. In that case, you're going to fill out this document, which says without release of earnest money, so that you know the difference. Top section is all the same. What's the date of the purchase agreement? Who's the seller? Who's the buyers? What's the property address? Then it's going to put in the people's name. And I was messing with some templates here, which is why it has my name in it. On your blank documents, it won't have anything. But it'll say it'll release Keller Williams Elite and XYZ Realty again. But it also goes on in this middle section to say earnest money shall be administered as described in KRS 324.111. So again, this form is only if they don't agree. On the HCAR section, it has a section for you to be able to fill out, which we went over earlier in this video, and you can reference that. Then everybody signs. At the point this is signed, then you'll need to, if we're holding the earnest money, you'll send a copy of this over to Bella at the front desk, and that will initiate the earnest money to be paid out. Not on this form, excuse me, on the form that earnest money is actually going out. In this situation, regardless of which brokerage you're at, if we have to rely on the KREC state regulations to determine where the earnest money goes, I actually pulled those from the KREC website. And I want to highlight section 6 here, which clearly defines exactly what's going to happen. Now, all of you can read through this and understand what this means, but I'm going to summarize it for you. Starting right here, it says, let me highlight this for 1 second. Down through mailing date. Right here's the most important part. If parties can't agree, then here's what happens. The broker who is holding the earnest money, so whichever company's holding the earnest money, that broker has to notify all the parties using their last known address by certified mail that the contract deposit shall be distributed to the party specified in the letter. What this means is the broker is going to make a determination based off the contract, based on talking to you, based on talking to the other broker, talking to everybody. They're going to gather all the information, then they're going to make a determination on who they feel like the earnest money should go to. Then the broker is going to send a certified letter to all the parties notifying them that if they don't do one of a couple different things, then that money after 60 days is going to go to the person that they specify. So if the broker specifies it's going to the buyer, after 60 days, that money is going to be released to the buyer unless one of two things happens. Number one is unless everybody decides to sign a mutual release saying it's going to go somewhere else. So for example, if in our case, Kelly decides this is going to go to the buyer client, and then all the parties get together and say, hey, you know what? We've had a change of heart. We agree it's going to go to the seller. You fill out the mutual release form with earnest money going to the seller. That stops the system. Now the money can go to the seller. At the same time, if for whatever reason the seller decides, hey, I'm not going to fight anymore, I want to move on, I'm willing to just go ahead and sign this so that the buyer doesn't have to wait 60 days. Fill out that form. It allows us to skip the 60 days. If they don't skip the 60 days, the only other option that can prevent that earnest money from going out to where the broker decides is if the one or more, so either party or both parties, initiates litigation within 60 days of the mailing date. So they either have to get a release signed saying that, hey, we will agree for it to go to this particular person, or hey, thumbs up, or they have to start litigation, basically mediation, litigation, law, court, things like that. If that doesn't happen, then after 60 days, the broker may release the deposit to the party identified in the certified letter without penalty and without any future repercussions. So that is, just wanted to explain that process. I don't think a lot of people fully understand that this is why it's so important who holds the earnest money, because ultimately, if parties can't reach a mutual agreement, then the broker holding the earnest money is going to be the ultimate deciding factor inside of that. And while I firmly believe that all brokers are going to do the right thing and the legal thing. It's out of our control if it's not inside of our brokerage, and it's out of Kelly's control if it's not inside our brokerage. So I just wanted to touch base on this and explain this section and what this process looks like, and also let you all know how important it potentially could be that earnest money gets held at our brokerage any opportunity that it can. So. But that's earnest money releases. I wanted to go through that because I had a couple questions on that recently in the last few weeks. So I just wanted to summarize it real quick. So now I'll just see, do any of y'all have any questions on earnest money release or any of the forms that I just went over? Awesome. All right. Well, then you all know how to officially release a contract. You know what happens, and you can explain to your clients what happens moving forward. And as always, if you have any questions on this, you run into any issues, don't hesitate to reach out to either myself or, especially if it's an earnest money release, probably Kelly, but I don't mind to help out in some way, shape, or form. And I'll tell you if it needs to escalate to Kelly. But reach out to me if you have any questions. Other than that, I'll see you. Actually, next week's fall break, so we're not doing these classes. I'll see you the week after for our next contracts training. Appreciate y'all hopping in.